nuts and bolts of elder law. We are thrilled to have you join us today. My name is Jordan Parr, and I'm Assistant Program Co-Chair of the Beverly Hills Bar Association's Trust and Estates Law section. Before we begin, I'd like to take a moment to thank our sponsors. The BHBA's Trust and Estates section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, Pickford Escrow Company, as well as the Sanborn team. Now, on to the program. I'm happy to introduce today's speaker, Justin McDermott. Justin is an attorney at the law offices of Stewart Zimmering, where he practiced since 2015. He focuses on elder law, estate and life planning, special needs trusts, public benefits, conservatorships, and probate and trust administration. Justin is a member of the State Bar of California Trust and Estate section, the San Fernando Valley Bar Association Probate and Estate Planning section, Los Angeles County Bar Association's Trust and Estate section, the National Academy of Elder Law Attorneys, NAELA, and the Southern California NAELA chapter, of which he is a member of the executive board and the current president. We can't wait to see what he has to share with us today. Justin, the floor is yours.
Thanks so much, Jordan, and also Suzanne for inviting me to present today. And good afternoon, everyone. Welcome to the nuts and bolts of elder law, or Elder Law 101, as I like to call it. As Jordan said, I'm Justin McDermott. I'm an attorney who works with Stewart Zimmering in Encino. We are elder law attorneys, and just housekeeping. If anyone has questions during the presentation, you should enter them into the Q&A chat box, and then I'll hopefully be able to respond to them, or certainly you can wait until the end, and I'd be happy to answer what I can then. So, what is elder law? Simply put, elder law is the legal practice of counseling and representing older persons or their representatives. Some history about elder law. Elder law has been identified as a practice area for about 20 years. The catalyst was former LCS, which stands for Legal Services Corporations, which were nonprofits established by Congress to provide funding to 130 plus independent legal aid organizations throughout the country. Elder law then evolved into a discrete practice area because of the increasing number of elders, the complexity of area of law, and the unmet needs of an aging client base. How did elder law get organized? The National Academy of Elder Law Attorneys formed in 1988. NAELA has now grown to over 5,000 nationwide members. A number of state bars have elder law sections, and some have special needs planning sections. NAELA also now has 31 state independent chapters. There are also other organizations such as the American Bar Association or the American College of Trust and Estate Counsel, which also have elder law sections and committees. As of 2025, California no longer has two chapters for NAELA, SoCal and NorCal. Just this year, we have merged the organization into one, and we have just Cal NAELA it's referred to now, and we have a membership base of around 125 people. So what's in a name? Initially, the area of law was referred to as law and aging or aging in law. Sometimes it was referred to as elderly law. NAELA founders debated the name and elected to go with academy as opposed to association. Eventually, elder law has become the accepted term. But does this now need to be rethought in light of the boomers? Elder law for boomers? Also, what about the children being served? Boomers certainly don't see themselves as needing an elder law attorney, and no one believes that elder law attorneys, or I should say, no one, when they hear the word elder law attorney, thinks this person also does special needs planning for children. Note that the ABA Commission on Legal Problems of the Elderly changed its name to the ABA Commission on Law and Aging, and the American Association of Retired Persons recently changed its name to simply AARP. Why be an elder law attorney? It's a growth industry. Elder law has changed from a niche practice to a general practice area elder law has changed from a niche practice area to a general area within which one may specialize. There's positive demographics. From the Census Bureau, there's 3 categories: boomers, older than 55 plus population, and then the elderly 65 plus population. 76 million baby boomers equals 31% of the current population, and 9 of 10 are predicted to retire by 2030. Also by 2030, 1 of 5 will be boomers between the ages of 66 and 84. Of that group, women 65 and over outratio men, 20.6 million to 14.4 million. As of 2024, there are around 61.2 million Americans age 65 and older, a 3.1% increase from the prior year. The share of 65 plus in the total population rose from 12.4% in 2004 to 18% in 2024. From 2020 to 2024, the 65 plus population grew by 13%, which vastly outpaced working age adults, which only grew by 1.4%. Projections for 2025 estimate the 65 and over population will increase from 58 million in 2022 to 82 million, rising from 17% to 23% of the total population, which means that almost 1 in 4 of us will need an elder law attorney at some point. The West and South regions will have the most population growth in both total population and 65 and over population. While elderly individuals may retire below the Sun Belt, they may also need to return home or move closer to their family support system if they become quote unquote frail or need what we'll talk more about later, which is some sort of institutionalized care setting. The key to the growth of the elder law practice is demographics and practice growth. And boomers are the key. They are the children of the elderly parents. They are that are providing the caregiving and planning and learning about their own futures. They're often referred to as the sandwich generation because they're taking care of both their elderly parents and their own children, sometimes all within the same home. So who are our clients? Is it age-based? Is it at 65? What's old? The answer really depends upon the health, disabilities, or special needs of the potential client. California currently has about 39 million residents, and the population over age 60 will have an overall increase of 166% during the time period from 2010 to 2060. More than half of our counties will have over a 100% increase in this age group, and 24 of the counties will have growth rates of over 150%. Yet in the face of what is an aging tsunami, California's current NALA membership is only 126 members. So what are the core legal elements of elder law? What types of things do elder law attorneys do on a day-to-day basis? Elder law attorneys typically take a holistic approach to estate planning, which includes the management of estates during life and distribution on death via trusts, wills, etc. We're more focused on the health, personal, and long-term care planning interests of the individual. We do disability and incapacity planning, which includes durable powers of attorney, living trusts, living wills, as they're referred to in most other states. In California, we refer to them as advanced healthcare directives, and certainly HIPAA authorizations. A lot of what we do deals with healthcare delegation of management and decision-making to another party in the case of an elderly client's incapacity or incompetency. We represent fiduciaries as agents under durable powers of attorney, and we provide assistance with surrogate decision-making, such as conservatorships in California and guardianships for minors. Elder law attorneys do a lot of legal capacity counseling. We both evaluate, and if we are unsure about a capacity diagnosis or situation, we very regularly refer those individuals out to be evaluated by an appropriate professional. Elder law attorneys provide public benefit planning advice. That includes Medicaid in California, Medi-Cal, Medicare, Social Security, which includes both SSI, SSDI, and retirement benefits, Section 8 housing, and CalFresh benefits or food stamps. There's important differences between what is a means-tested public benefit and what is not. So, for example, Medicare and SSDI are not means-tested public benefits. What that means is we pay taxes into a system during our working careers, which in the event of a disability allows us to receive SSDI. Same thing with Medicare. If you contribute to the system and you've earned enough credits at age 65, you are entitled to it. This is very different than SSI, Medi-Cal, Section 8, and CalFresh. All of those benefits are means tested. And what that means is, for example, SSI, you may only have $2,000 and a limited amount of income. We'll talk more about the changing Medi-Cal rules in the future. Section 8 now does have an asset test. It depends upon what county you're in, and an income test. And I believe that CalFresh does not have an asset test, but an income test. Nonetheless, any benefits that are based upon your income are means tested. We handle the conservation, disposition, and administration of estates. So that means trust administrations and the probating of estates. We also need to be careful about the implementation of decisions that have potential tax consequences. This is especially true in the realm of capital gains taxes and real property taxes in light of Prop 19. We are not tax experts here, but we know enough to identify when we can handle it on our own and when we need to refer the client out for more sophisticated tax advice. Elder law attorneys handle Medi-Cal. Well, I should say not all elder law attorneys handle Medi-Cal, Medicare claims and appeals, and Social Security and disability claims and appeals. We do them sort of on a case-by-case basis and work with other lawyers whose entire practices may focus on Social Security or Medicare issues in particular. We are asked to provide supplemental and long-term care insurance advice at times. We review long-term care placement contracts at skilled nursing facilities and continuing care retirement contracts, continuing care retirement community contracts. Medicaid, which we refer to in California as Medi-Cal, we handle eligibility and qualification. However, there are brand new rules beginning in 2026. So since 2024, there has not been an asset test in California. But it's being reinstated on January 1st of 2026. What the reinstated asset test will mean is that a single person may only have $130,000 of non-exempt assets. Now, certain assets are exempt, such as a home, a vehicle, and another example is as long as your retirement accounts are in pay status, meaning you're receiving required minimum distributions, the principal itself is not counted. Only the income that flows off that retirement account is counted. In January of 2026, a married couple may have $195,000 of total assets, again, not including the exempt assets, with an additional $65,000 for each additional household member, up to a maximum of 10. It's important to note, and we're sending a letter to all our clients reminding them that prior to January 1st, 2026, there are no transfer penalties or what used to be called look-back periods. What that means is anything can be transferred such that if it's done before January 2026, you'll have no effect on any type of public benefit eligibility. Additionally, California is unique in that it's one of the few states that still allows what we refer to as stacked gifting, where transfers under what is referred to as the average private pay rate for a nursing home, that current amount is set at $13,656 and goes up a little each year. I'm not going to get into the details of stacked gifting, but the point is that if you gift 13,656 or less, for Medi-Cal eligibility purposes, the gift is rounded down and counts as zero. Offline or later, if anybody has more questions about stack gifting, I'd be happy to go through it. We also handle the preservation and transfer of assets to avoid spousal impoverishment when one spouse requires institutionalized care and the other spouse is able to remain at home. And we call that spouse the well spouse. Individuals in that situation, meaning you have one well spouse able to be at home and one incapacitated spouse who needs skilled nursing care, the Community Spouse Resource Allowance, there's a lot of acronyms here, or CSRA, will be $157,920 or more in 2026. And the minimum monthly maintenance needs allowance, or MIMNA, is currently at $3,948 per month and also goes up annually. What does this mean? This means that the well spouse at home can have $157,920 of countable resources. That again doesn't include the home, a vehicle. We already talked about some retirement accounts as long as they're in pay status. And that's the amount that the well spouse may keep and still qualify the institutionalized spouse for Medi-Cal. The MIMNA is the amount that the well spouse is guaranteed to receive from whatever resources the couples have before any funds are distributed to the skilled nursing facility. Special needs planning. As I mentioned, elder law attorneys, one of the biggest areas of our practice is that we do a ton of special needs planning. So, what types of special needs trusts are there? There are first party special needs trusts, there are third party special needs trust, and there are what's called pooled or group special needs trusts. Now, the easiest way to understand the difference between these types of trusts is that a first party trust is a trust established with the beneficiary's own money, okay? The first party trusts also come with a required Medi-Cal estate recovery payback provision prior to any distributions which are remaining being passed to the family members. Third-party special needs trusts are anyone's money other than the beneficiaries. So that would be mom and dad, that would be grandma and grandpa, it could be anyone other than the beneficiaries. Last, a pooled or a group special needs trust is really meant for one of two things. Either individuals over age 65 who can no longer set up their own first party pooled trust, or I'm sorry, the first caveat is individuals over 65 can't set up their own first party trust. They must use a pooled or group trust. The second reason for a pooled or group trust is where the principal amount, maybe it came from some litigation where it's not a huge sum. Maybe it's $50,000. That is, it's a much cheaper, better economic way to join the pool with a smaller amount of principal, where the principal throughout the entire pool is invested together as a group. While we don't handle much nursing home litigation at all, and also don't really handle elder abuse litigation, again, there are attorneys who specialize in nursing home issues, whether it be patients' rights or nursing home equality or nursing home quality. Certainly elder abuse, financial exploitation, recovery cases, elder abuse, whether in the form of physical abuse, neglect, or isolation, and then of course, financial exploitation. There are housing issues, including discrimination and advice regarding home equity conversions. There are issues in age discrimination with employment. Again, that's more for a litigator than for our practice. Nonetheless, it's needed. Advice is given regarding retirement, including benefits, whether they be retirement, survivor benefits, also pension benefit advice. In other words, to sum up, the practice of elder law truly does cover the gamut of possibly every legal problem an elderly client may have. And again, I don't want to make anyone think that one firm handles all these types of issues. It is certainly a subspecialty niche depending upon the subject matter. Now, Guardianships are what most states refer to as adult guardianships. However, in California, we call them conservatorships, and guardianships are only for minors. Now, certainly a guardianship or a conservatorship is a drastic step taken only when there are no less restrictive alternatives that will suffice. Now, this case is a Tennessee case, which summarizes, I think, the whole point of a conservatorship proceeding, and I just want to read it to you all quickly. Participants in conservatorship proceedings involving elderly persons should avoid the subtle influences of ageism and the double standards that accompany it. The aging process by itself is not a disabling condition, and being elderly is not tantamount to being disabled. The popular notion that the aging process entails progressive decline in capacity or competence vastly oversimplifies a complex process that affects an extraordinarily large and diverse group of persons. So, to that end, wherever possible, conservatorships should be limited to the extent necessary to meet the ward's incapacity and not be plenary unless it's needed. Now, in California, there are a number of different types of conservatorships. The first is what we refer to as a general probate conservatorship, which is appropriate for individuals who are unable to manage their own affairs or resist fraud and undue influence. There is what we call limited conservatorships, which are geared for your regional center clients. And those are more high-functioning individuals with some sort of intellectual disability. Finally, there's the LPS, or mental health and substance abuse conservatorship. And unfortunately, with the LPS, only the public guardian's office or certain designated healthcare professionals are able to petition. The family is not able to petition for a LPS conservatorship, which is sometimes quite frustrating for them. There is a new substituted decision-making option in California. It's a new, less restrictive system, which is available as an alternative to conservatorships. It was enacted by Assembly Bill 1663 and effective on January 1st of 2023. And it allows an adult with a disability to choose trusted individuals to help them understand and make their own decisions rather than having a court-appointed conservator make decisions for them. Oftentimes, the dispute is over who should be the conservator and not really whether the conservatorship itself is needed. If an attorney is appointed by the court as an attorney for the potential conservatee, it's now called a CAC appointment, which stands for Court Appointed Counsel. It was formerly referred to as PVP, which was Probate Volunteer Panel. And it's important to remember that the CAC attorney's role is to advocate on behalf of the conservatee, their best interest, and to make the potential conservatee's wishes about the conservatorship known. It is quite different than a guardian ad litem situation. Fees in a guardianship, conservatorship, and the attorneys for the fees. It's very important that we use care and keep excellent records. We need to educate the guardian or conservator and review all the reports that are issued, whether from the probate investigator, physician reports. We need to review all of them. It is common that there are court supervised accountings and also court supervised special needs trusts where a beneficiary is incapacitated. We do our best to plan for incapacity, and we execute all the estate planning documents possible, but there's always a risk that we may not be able to prevent a conservatorship in the end. Now, the whole purpose of having an estate plan is to avoid the cost and necessity of a conservatorship. But what happens when grandma or grandpa revokes their powers of attorney or just refuses to do what we all know is in their best interest? That's a tricky situation, and one where a conservatorship may not be needed because the estate planning documents can no longer be relied on. The difference, I would say, between a traditional elder law attorney practice and traditional estate planning is that elder law attorneys take that holistic approach. We're more focused on health-related concerns. We're focused on fears of isolation. We are focused on looming financial problems, which may come in the future, depending upon healthcare needs. We are, and on our business cards, it says we are attorneys and counselors at law, and we do attorney work and we do a lot of counseling work. Our office, I would tell you, has more of a doctor's office vibe about it as opposed to a traditional attorney's law office. And a lot of our clients often think that we have a background in social work, which we do not, but we have acquired a lot of experience in counseling families through moments of crisis. Now, the most important societal values that we care about are we're just focused on independence and autonomy and ensuring that our clients are able to are able to age in place to the extent possible. Okay, so elder law attorneys know more than just the law, but what sets us apart from other attorneys? Elder law attorneys traditionally have a greater knowledge of the elder population themselves, which allows the attorneys and our staffs to ignore myths about aging or competence. Keep in mind that we see diminishing capacity all the time, which is not necessarily a lack of capacity. We take into account and empathize with true physical and mental disabilities, mental difficulties accompanying aging. We're traditionally more familiar with conditions such as dementia and Alzheimer's, and we're more aware of real life problems, health and otherwise, which occur in aging. Suzanne, we're at the slide after life planning versus traditional estate planning. Next slide. Okay. Elder law attorneys are tied into networks of social workers, psychologists, and other elder care professionals who may assist us. That can be geriatric MDs, it can be geriatric neuro psychologist or psychiatrist or psychologists in general. Elder law attorneys know about professional and non-legal resources and services, both publicly and privately available, to meet the needs, and are capable of recognizing the professional conduct and ethical issues that arise throughout representations. Although elder law attorneys are not normally physicians, we are more trained to assess an older person's legal capacity. Now, since most of us are not physicians, we in our office often use the Assessment of Older Adults with Diminished Capacity, a handbook for lawyers. Now, this was a collaboration between attorneys and psychologists, and it includes suggestions for attorneys in terms of balancing autonomy and protection. There is a link to it online. If you are in these practice areas and don't have one, I would suggest buying it. It's not too expensive. So there are elder law concerns which are legal and non-legal, of course, and there's an important interplay between the two. What are some of the legal issues? We've talked about healthcare issues, including surrogate decision-making, public benefits, paying for healthcare. There are, of course, capacity issues, the need to plan for incapacity. Alternatives to guardianship should always be considered, such as durable powers of attorney, trusts, and other ways of transferring ownership. We need to remember that capacity is fluid rather than all or nothing, and that different legal tasks require different levels of capacity. So testamentary capacity is a basic level, whereas contractual capacity, for example, is a higher level of capacity. Other legal issues include housing and the continuum from independent living, maybe being on a program such as IHSS, which is in-home support services, by the way, to shared housing or supervised housing, like being in an assisted living situation. There are Medi-Cal assisted living waiver programs for that. And then, of course, those who need skilled nursing care, and for that level of care, what clients are most normally interested is qualifying for the Medi-Cal long-term care program. Again, public benefits, the important interplay between them and action taking for the client. We always need to be very careful upfront to make sure we know what each client's benefits are. All of them. We always need to know, because it's important that we don't inadvertently impact the client's eligibility for those benefits. We talked briefly about elder abuse litigation earlier. It can include physiological, psychological, sexual, or financial exploitation. Income security issues like Social Security, SSI, SSDI, veterans benefits, which is also more of a niche specialized practice. We don't do too much VA work here. Of course, dealing with pension plans, handling debts, and of course, the possibility of bankruptcy. Now, elders incurring large amounts of debt and considering filing for bankruptcy. So we don't handle bankruptcy here, but there are various reasons that could have caused the financial difficulty: being laid off, increasing healthcare costs, pension plan problems, credit card usage. Also, we can't forget about consumer problems like fraud and all of these elder scams that we all have heard of from time to time. There was a new bankruptcy law, and we believe it will affect elderly debtors. There was a major development in 2025, which included the inflation-driven increases to the bankruptcy exemption amounts, expanded protection for retirement funds, and overall proposed legislation that could significantly restructure consumer bankruptcy. We deal with end of life issues here. What does the law provide regarding the withdrawing of life prolonging procedures? In California, we have the California End of Life Option Act, which allows eligible adult residents with terminal illnesses to request and receive a prescription for self-administered medication to hasten their death. It was signed into law in 2015. The act was a response to the growing movement for physician-assisted suicide, providing a legal framework for medical aid in dying under specific conditions. The problem that we have noticed with the law is sometimes there are conditions which are not terminal, where the person may still want to end their life. Secondarily, an incapacitated individual cannot elect to use this California end of life option. The person must have capacity. Again, multiple doctors must sign off, and they must be able to self-administer the medication. Again, some of the key requirements include multiple physicians, patient self-administration, and certain protections against discrimination. Now, a warning we have for estate planning attorneys out there is that you need to be careful using quote unquote suggested or statutory forms. For example, there's a statutory form power of attorney, there's a statutory form advanced healthcare directive, there's a statutory form HIPAA, and the issue is that some specific authority is lacking in those documents. They're intended to be very, very basic. So here we only craft custom durable powers of attorney and custom advanced healthcare directives. Why do we do that? Because it's really important that the directive accurately reflects the client's wishes. A lot of the forms are check a box, give someone authority, but there's no specificity as to what mom or dad or grandma and grandpa would want. It's just, you have the ability to make a decision for me. Well, what decision would they want? So it's very important, in our opinion, to have custom powers of attorney for both assets and healthcare, such that in the event the incapacitated individual's agent is asked a question by the doctor, they're consulting the well-crafted directive to get the answer they need to the specific situation. We make our clients go through an almost painful exercise of so many different things that have happened to our clients over the last 50 years that this firm's been here. And we give them an opportunity to think about what would happen or how would they feel if they were in a particular situation. And then they get to customize their responses based upon the situations that we have prompted them with. Also, we want to make sure always to include HIPAA compliant language. And there's a link to a resource there if you're unsure where to find that. If the client is in the facility, it's important to know, is there a specific policy that honors advance directives. Of course, drafting is only the first step. It's critical for the client to have conversations with both their family and their doctors about their wishes and reasons. And what we always tell people while they're customizing our advance directives is it's really important that you discuss this with your doctor. Bring it to him next time you have an appointment, or send it to him, and just make sure that everyone is on the same page. A toolkit exists from the ABA in terms of a toolkit for healthcare advanced planning options. If, again, you're looking for a resource, the link is there. The estate planning and family law intersection occurs when you represent a husband and wife and they call you and say, we're getting a divorce. What do we do? The answer is not much, due to the ATROs, which are automatic temporary restraining orders, which essentially prevents spouses from transferring assets or doing new estate planning until the dissolution of marriage is actually granted. Now, it's super important when we meet with potential clients. Is this a first, second, or third marriage? Who has adult children from which marriage? We need to we need to figure out all those parameters at the outset to ensure that we can plan accurately. What happens if one spouse is alleged or is incapacitated? There are petitions under Probate Code Section 3100, which allow the non-incapacitated spouse to petition for a certain transaction for the benefit of the incapacitated spouse. What's a quick example of that? Let's say a well spouse sets up an estate plan and half of the home is owned by the wife and the husband puts his half into the trust. You would file a Probate Code 13100 petition to seek court approval to transfer wife's half of the home into the trust, which benefits the both of them. Now, we don't handle family law, but I find it interesting that if anyone is incapacitated, is a divorce possible? Or what if it occurs while a petition is pending? I can't tell you how important capacity truly is, and being sure that you determine at the outset what level of capacity the client is working with. There are disability issues, and the National Organization of Social Security Claimants Representatives can assist individuals, whether it be old clients, young clients. They can give some advice related to special needs trusts and public benefit planning, and they often work with attorneys as resources in settlement cases. Now, what happens most often is a PI attorney will settle a case for X amount of money, and that client receives public benefits. So what do you do? And the answer is, it depends on the person's capacity, but if they have capacity, we could do special needs planning for them, and the attorneys can then fund the trust. And if the person lacks capacity, then you're dealing with more court involvement. We already talked about document drafting and just assuring capacity issues, and we'll talk more about ethical representation of elderly clients in a couple minutes. The whole point is just to ensure that the documents reflect the client's decision and accomplish whatever their objectives are. Now, there are Non-legal issues such as choosing a nursing home, care planning, finding a care management company, bringing in supportive services. There are social service agencies and programs which provide assistance with that. Of course, there are non-legal issues unrelated to dying, like where are you going to be buried? Do you want to be cremated? Things of that matter. Dementia, depression, health problems. How do they affect capacity if they do at all? How can we deal with the diagnosis, and is it treatable? Although it's rare, there are times where we represent people who, for whatever reason, have capacity, lose capacity, regain capacity. So it's not impossible, although rare. Finally, medications, interactions which affect client physically or mentally, the costs of their medications, those are all non-legal issues. So more non-legal issues are family dynamics, which can be a major positive or a major negative, which can have a major positive or major negative impact on the client. Again, we'll talk about ethical issues more. Physical disabilities, is the client taking pain medications? If that may be the case, or they're unable to travel, oftentimes we will do a site visit or a house call. It's not often because it makes it a little bit more expensive, but it certainly happens semi-regularly. Age, the extremely old may have some problems that will necessitate flexibility into the approach. Again, we may have to go to the client rather than having the client come to us. Driving, how do we advise the family on how to get dad to stop driving? The next slide I'm not going to go through, but that's just some resources where you can get information about having this conversation. We will talk briefly about driving in seniors. So just by the numbers, in 2004, 80% of people over 65 had a driver's license. In 2025, the number of drivers over 65 will increase by 250%. Senior drivers have more accidents per mile driven, but the elderly drive fewer miles in general than other age groups. Senior drivers are, of course, more likely to be injured, and they're more likely to die as a result of automobile accidents. Vehicular accidents are the second leading cause of death due to injury of those above 55. What duty do professionals have to warn the public? The answer is that the medical community does have some guidelines. The current AMA guidelines permit MDs to report serious driving impairments to DMVs. 11 states currently require MDs to report certain conditions, but importantly, no other professionals have a duty to report, and that's particularly true about our own clients and attorneys representing individuals in California. So what are some solutions? We need to ask questions as part of the intake. Do you drive? How far? How do you consider your driving skills? We certainly recommend regular insurance checkups. Is there adequate coverage? We can add language to powers of attorney in the hope that the DMV will honor that in terms of potentially agent use at a DMV. You can become familiar with local programs such as AARP Driver Safety Program, the link's there. And there's a network of occupational therapists who specialize in driver rehabilitation. Okay, next, so non-legal issues can impact how you practice elder law, and in particular, your client's case. So very old clients, of course, may present greater challenges for the elder law attorney. Lawrence Froelich, who is a professor of law at Pitt and a national expert on the legal issues facing older Americans, wrote the book Old Age with Fears and Ills: Planning for the Very Old Client. It's a wonderful resource. Elder law attorneys must make decisions about clients having sufficient capacity to take the desired action and need tools to evaluate the client's capacity. Again, the ABA handbook. And for example, one of the most important basic thing when you meet a client is, do they even have the capacity to hire you? Of course, we need to remember not to stereotype. The client may be old, but not suffering any stereotypical infirmities of aging. Elder law office issues, just briefly. Who should be on the staff? Paralegal, care manager, nurse? While we don't have a care manager or nurse on our staff, we have plenty of connections to those types of individuals, including, of course, geriatric care managers. Ratio of paralegals to attorneys, how many do you need? It depends. We have 2 assistants, we have 2 paralegals, and we have 2 attorneys here, plus an office manager. Again, care planning has a role in the practice, and if anyone needs referrals to many different GCMs in LA, I'd be happy to send them if you contact me offline. Is the office elder friendly? Our office is ADA compliant. We did think about the physical acts, the physical space flooring, the lighting, the furniture, soundproofing, location and accessibility, staff training. Our office has wide hallways. Anyone in a wheelchair can move easily. We have carpet, which makes it really easy to move around. We have soundproofed rooms in our conference room, so there's no concerns about any privacy issues. All right, so I want to touch briefly on some ethical issues in representing persons with disabilities and their families. So it's important to always keep in mind from the beginning, who is the client going to be? Okay, you've got to identify that at the outset. Can the family be the client? We'll talk about the communitarian approach in a minute. There is joint representation, so husband and wife. We'll talk about interspousal conflict waivers. There's husband or wife. You represent one spouse, but not the other. There's parent and child. We'll talk about intergenerational family conflict waivers, and then a few multidisciplinary issues and capacity issues. So let's just do a hypothetical. So we're going to set the stage by the daughter calls. Her father has suffered a massive stroke. Her mother is unable to cope. Children are scattered with mixed agendas. Mom is giving them conflicting, incoherent reports. They have heard rumors about nursing homes. All the family's assets will be consumed. The state will take the parents home if they seek public assistance, and mom will be tossed out on the street. If dad is able to come home, he will require 24/7 care. They should either start looking for a caregiver or a nursing home. The daughter informs you that they, the children and mom, want to schedule an appointment to discuss their options. The daughter and the mother will attend in person, and the other children will participate by conference call. How should you respond? Now, I'm not going to ask you guys to provide a response, but here would be my response. Step 1, you're going to request info about dad's condition and all the couple's existing estate planning documents. You're going to obtain a family consultation and disclosure authorization, where you're going to disclose the duty of confidentiality and loyalty and waiver of privilege because other family members are present during the initial consultation. You're going to explain that mom or dad will be the client unless daughter has a valid power of attorney, which we would need to review first, and that the attorney will need to meet with mom alone for at least some amount of time before the daughter or any other children are allowed to join. It would be my preference, given the hypo, that dad not attend the initial meeting. The reason why is if he needs a conservator, we are not able to petition to establish a conservatorship over a potential client or a current client. So it would be my preference that he stays at home. We review all the documents, we get a sense of the assets and income, and then we can talk about next steps. Finally, we never allow anyone to retain us on the same day. We will always follow up with an attorney-client retainer agreement, outlining, of course, what work we're going to do and the related costs, and provide an optional disclosure authorization for the kids if the parents want one. Obviously, kids always think their parents approve. It's not always the case. So a quick little joke that our law firm's motto is dysfunctional family is redundant. We see the same issues with all different types of families all the time. My family, other people's families, every family is a dysfunctional family, at least most times. Quickly about the communitarian approach. What that is that's representing sort of a family in a counseling setting where there's been no prior representations of any party. You're just providing counseling, trying to help solve a problem. You've obviously got full disclosure authorizations and waivers in advance. In terms of joint representation, if you're going to represent a husband and wife, you of course need an interspousal conflict waiver. One spouse, nothing's necessarily needed. Parents and child, it's very common that we represent multiple generations of a family. So grandma and grandpa, then the kids come to us, mom and dad, right? It continues. So we always have a multi-generational conflict waiver, which says we represent different units of the family. They're free to do whatever they want with their estate planning, period. Then, of course, we represent agents under durable powers of attorney. Again, the most important thing about waivers of potential conflict of interest is to get it in writing and in advance. Now, joint representation in terms of NAILA aspirational standards. Now, what NAILA aspirational standards are, they are guidelines for ethical best practices for elder law attorneys. They are not law, but they are guidelines. So for example, in addition to the California Rules of Professional Conduct, the California Business and Professions Code, and any other state statutes or the ABA's Model Rules of Professional Conduct, what NAILA Aspirational Standard B1 says is that the elder law attorney must ensure that the family members understand who are the clients and whether the representation is joint, where confidences are shared, or separate. B2 undertakes joint representation only after obtaining consent. Of course, we just talked about that. I see we're kind of getting to the end. So Suzanne, I think we'll skip. I'll just briefly. So in terms of issues with capacity, if you've got an existing client where his family wants to petition for a conservatorship, again, we can't be involved. They can hire another attorney to do that, but that can't be us. If the client, however, himself voluntarily requests or consents to a conservatorship, then we may be involved. Next slide. Next slide. So just some conflict issues. The ABA Model Rule of Professional Conduct 1.7, a lawyer shall not represent a client if the representation of that client will be directly adverse. Unless the lawyer reasonably believes the representation will not adversely affect the relationship with the other client and both clients consent. I think everyone's familiar with those. We can skip the next conflict. Then California Rule of Professional Conduct, Rule 3-310C. A member shall not, without the informed written consent of each client, accept representation of more than one client in a matter in which the interests of the clients potentially conflict etc. These are all similar but different. Payment by third parties, also a California rule of professional conduct. A member shall not affect compensation for the representation of a client from one other than the client unless there is no interference with the member's independence of professional judgment or with the client-lawyer relationship. And we'll skip that next page. You guys are all familiar with payment from third parties as well. Now, I just want to reiterate the NAILA aspirational standard for payment by third parties. The elder law attorney accepts payment of client fees by a third party only after determining that the payment by the third party will not influence the attorney's independent professional judgment on behalf of the client, informing the client who consents to the payment by a third party, and ensuring that the parties understand and agree to the ethical ground rules for third payment. We'll skip the next multidisciplinary issue slide. And then just conflicts and conundra about geriatric care managers. Geriatric care managers do have a pledge of ethics. And what it says is, I will hold in trust any confidence you give, disclosing information to others only with your permission, or if I am compelled to do so by my belief that you will be seriously harmed by my silence, or if the laws of this state require me to do so. We'll skip the next slide and go to the last hypothetical. So Sadie Sr. is represented by elder law attorney and her employed GCM. Sadie confides in GCM that Snively Whiplash, her grandson, has taken her credit cards and jewelry, threatening her that if she tells anyone, he will harm her cats, Munchin and Misty, the loves of her life. The GCM tells her employer, who calls Sadie and confirms these facts, but also specifically instructs the attorney to not say a word. What would you do? What should you do? So again, my answer is, first, you must honor the client's request. Second, I think it might be fair to make a suggestion to the GCM or to another family member, if possible, to call and report what is a form of elder abuse to Adult Protective Services. Adult Protective Services will investigate, and the reporting itself is anonymous. So you can always tell the person, no one's going to find out that you were the one who reported. Actually, you only find out the results of the investigation if action is taken. Now, the next two slides are just some additional resources that I thought might be helpful for everyone to have. There's, of course, membership. I'd encourage anyone practicing elder law to join both National NAILA and certainly California NAILA. It's not too expensive. I believe our fees in California are $95 a year. It does include quarterly meetings, an annual summit, and a few other items. In terms of actual practice materials, there's Elder Law Practice in Tennessee by Timothy Takis. There's Takis and McGuffey Revisiting the Ethics of Medicaid Planning, Tax, Estate, and Financial Planning by Reagan, Morgan, and English. The Elder Law Answer Book by Robert Fleming, which is, Robert is an attorney in Arizona. It's a fantastic resource. There's the NAILA e-bulletin. Then also the Fundamentals of Special Needs Trust by Bradley Fergon, Rebecca Morgan, and Stuart Zimring, who I work with here. It is, if you do special needs planning, it's a book that must be on your desk. Finally, the National Senior Citizens Law Center has a Washington National Senior Citizens Law Center Washington Weekly has an email publication that you can be on. There are mentoring programs available through our state and NAILA if anyone's interested. And of course, if you need a list of any aging service providers, please feel free to reach out to me offline, and I would be happy to provide them to you. Last is, that's just our contact information for myself and Stu. Anyone can always feel free to reach out. I apologize. I realize I'm over by a few minutes, and I'm just going to take a quick look at the questions here. With respect to Medi-Cal, while there are asset limits for eligibility, if one is eligible and receives benefits, does the state require payment of those benefits after death? So the answer is it depends. I mean, where are the funds being held? Okay, so if it's in a traditional revocable trust in California, those assets are protected. If it's in a first party special needs trust, those assets are not protected. There's a payback provision required. And if it's a third party special needs trust, there's no Medi-Cal estate recovery component. Next question is, are the limits for Medi-Cal going to change? Well, we just discussed sort of the changes that are coming on January of 2026. We assume that those are the real numbers, but it's a fluid situation. Example of non-exempt assets for Medi-Cal, a home, a vehicle, the retirement accounts, as long as they're receiving required minimum distributions. And I'm just, okay, somebody just answered the question. Yep. The difference between a GAL and a CAC. Okay. If a person moving into a nursing home sells their house because they are long-term in the skilled, the answer is generally speaking, no. So if somebody sells their home, it goes from being exempt to being an accountable resource once it's converted to cash. So no, and last question, at least I'm seeing, is can attorneys call APS on behalf of their clients? Not in California. Other states, potentially, not in California. Well, if anyone has any other questions, I'm happy to stay as long as anyone would like. But otherwise, thank you again to Jordan and Suzanne for having me. And I really appreciate the opportunity to present for you all today at Beverly Hills Bar Association.
This concludes today's presentation. Thank you so much, Justin, for joining us today. And of course, to our audience, thank you for joining us. You're also most welcome to email Justin with any questions regarding this presentation. Have a great afternoon, everybody.